following orders and moving on. Asia is next, small place, couple of people living there, maybe a little bit larger than Antarctica, the last time I looked, so population-wise. And I also believe the home of many, many religions, but details aside. Welcome. Let me not spend too much time blabbering, but the panelists, let me get straight to the panel. Sophie will speak on right-wing movement in Malaysia. Marco will speak on the Supreme Court in India and religion, and Nargis Virani will be the discussant. Without further ado, 20 minutes. Sophie, the floor is yours.
I might need it. Well, thanks a lot for those of you who've been brave enough to stay here late tonight. So thanks, of course, to the organizer. I'm really glad to be in Berkeley again. Thanks to Hedy again and to John. So I'm actually going to talk more about a case study in order to nurture the debate. My paper that will be online in a few weeks will actually include a bit more theoretical and conceptual discussion. So this is the outline of the talk. So I think it's quite necessary to give you a bit of background about Malaysia, because I assume that a lot of us are not really familiar with the case. And so the background is needed in order to understand the origins and challenges of the revival of ethno-nationalism in Malaysia. So the talk will have two parts, an introduction and, of course, a conclusion. So Malaysia is historically at the crossroad of civilization. Contemporary Malaysia is a mosaic of language, culture, customs, and religion. It is often described as a multicultural and multi-religious country where communities live in peace and harmony. But the growing space occupied by religion in the public sphere and 50 years of ethnic-based politics have triggered many tensions. So the ethnic composition of Malaysia, in fact, since independence in 1957, Malays have been dominating the country's politics. Malaysia is a diverse country where 60% of the population is Muslim. Islam is the official religion of the federation, and where the ethnic distribution is virtually identical to the religious composition. So you can see that the largest part of the population in Malaysia is Bumiputra. I will come back on this concept later. Then you have a very important Chinese minority and then Indian. So most of the population is actually Muslim. So most of the Bumiputra are Muslim. And then we have Buddhist, Christian, and other faiths. So Malaysian society is a very divided society according to two essential parameters. Firstly, religion. Secondly, ethnicity. The difference between Muslim and non-Muslim pertains essentially to legal matters. Muslims are subjected to both Islamic and civil laws, while non-Muslims are subjected to civil laws only. Secondly, the ethnic criteria of differentiation creates two categories, Bumiputra and non-Bumiputra. Bumiputra meaning literally the son of the soil. The difference between the two concerns mostly economic privilege. Bumiputra is a virtual category with no legal basis, which includes Malay and native of Sabah and Sarawak, the states in Borneo, as well as indigenous people from the peninsula called Orang Zali. So the Bumiputra right concept follows the adage first come, first served. Bumiputra are seen as the first inhabitants of the territory and are considered to be entitled to a bigger share of resource. Since Malaysian independence, Malays and the native of Sabah and Sarawak have a special status regarding public services, education, land ownership, property acquisition, and business, as well as state leadership position, as stipulated by the national constitution. Adding to this, the successive economic policies of affirmative action started in the 70s, Bumiputra have enjoyed advantages in getting government position, university admittance, loans, investment shares, and public contract. Malaysia is actually one of the rare cases where affirmative action is directed to the majority. So to sum up, if Malaysians are unified under the banner of their citizenship, they are institutionally and constitutionally segregated. Each ethnic community has its own vernacular school, Chinese, Indian, and Malay, its own religion, Christian, Hindu, Muslim, Taoist, etc., and its own laws, Islamic or secular, or civil. The political landscape follows this pattern, and most political parties are ethnic-based. The UMNO represent the Malays, the MCA represent the Chinese, the MIC represent the Indian, and then we have a lot of other parties who would represent the indigenous population. So the impossibility of establishing a consensus over Malaysian identity has resulted in a polarization of ethnic and religious communities. The current tension between ethno-religious groups in Malaysia have been present since the independence of the country, leading to several racial riots and race-related violence over the years. In 64, 69, 2001, 2007, and 2010. So we can see that there's been an increase actually in race-related violence since 2001. So we are slowly going to the first part of my talk. So the consensus over Malaysian identity has proven to be a hard task for the successive governments since the independence. Prime Minister Najib, Prime Minister Najib's government is today facing the same issue of national identity, which as well is intrinsically linked to religious membership. In the case of France, as we've seen earlier today, the question is wrongly phrased by the government as how to integrate Muslim. Ironically, in Malaysia, the question is reversed and read as how to integrate non-Muslim. So the question is to which extent a government is able and allowed to influence and even shape the idea of national identity. The population of the Malaysian state, as it is defined today, has been recast from its origin by migrations, trade, and the colonial power. The original people of the territory, the indigenous, are today a minority. The Malays are seen as the true people, while Indian and Chinese are still considered as immigrants and thus still referred as Indian or Chinese. In fact, Najib's government did not intend to step into the national identity debate. Neither it tried to define or redefine Malaysian identity, but instead chose a cosmetic community rebinding strategy. Launched in 2009, One Malaysia campaign reaffirmed the beauty in its most naive sense of Malaysian diversity and unity. So here you have a few logos of the One Malaysia campaign was started in 2009. So the picture, the man that you see on the picture, raising his finger to make a one, is the Prime Minister Najib. And then on the bottom right of the slide, you can see the image of the launch of the campaign. So that was, so in 2009, it was in the biggest place in the center of the city called Merdeka Square. And the government organized a gigantic multicultural, multiracial, and multi-religious session of aerobic with the Prime Minister and his wife. So actually you can see that the lady, slightly overweight in the front, who is wearing a blue t-shirt, is the wife of the Prime Minister. So the campaign has several far-fetched sub-campaigns, including Formula One Malaysia and One Toilet. So, first we're going to play the Malaysia, the hymn. Well, we'll pass on the hymn. If you're really interested, I can show it to you later. So, to go back on the sub-campaigns, so Satu Tandas, or translated as One Toilet, was one of the sub-campaigns organized in the One Malaysia campaign. So it's very relevant for us academics. So the one Tandas, one toilet concept is actually to bring professor and student closer as a united nation. So in university and schools, they promoted the idea of having common toilets for professor and student. So as you can see here, this picture was actually taken from the website of one of the prominent bloggers in Malaysia. So you can see murid, meaning student, Cikgu is professor, and Guru Besar is the director of the school. So this is a united One Malaysia, One Toilet. So a year later, in a recent poll organized by Merdeka Center, very famous poll center, which is quite objective, from January to April 2010, that is to say about a year later, after the campaign was launched, 46% of the people interviewed affirmed that the concept of One Malaysia introduced by the government was a political agenda to win non-Malay votes. So, Ketuhanan Melayu, or Malay supremacy, is the motto of ethno-nationalist organization. Ethno-nationalist groups, registered as NGOs, are in fact on the edge between civil society and the political scene. Religion and identity are used as axiom of ralliement of the movement, which aims at securing political power and economic privilege for the Malay. Ethno-nationalist groups act as right-wing lobby or pressure group, seizing the emotion of their counterpart to awaken ethno-nationalist feelings through a tactic of media coup. The media coup strategy can be seen as a way to attract media attention by organizing bankable events or releasing powerful or shocking statements. This strategy is particularly observed in the context of religious controversy related to religious freedom and election. Both offer a virtual space of public debate through which those groups express their discourse, influencing both political parties, including the ruling party, and constituencies. These groups, known under the acronym of Pekida, Perkasa, Pewaris, and several others, are promoting the idea of a threat against Malay and Islam, embodied by Christian proselytism, non-Muslim minorities, and especially the Chinese. They cultivate the myth of an American Zionist conspiracy and the risk of seeing Chinese community taking power over the Malays. Ethno-nationalist groups do not push an Islamist agenda, but are the secular yet religious defender of Islam, which echoes the secular populist move to defend the Christian values explained by Olivier this morning. So here you see the logo of some of the main organizations. Pewaris is claimed to be the catalyst of the Malay Renaissance in the 21st century. Pewaris is actually a coalition of several NGOs, and Pekida is actually the organization that I'm concentrating my work on. It's an underground organization that I'm not going to talk about too much today, since the paper will be published and my fieldwork is ongoing, so they might not really appreciate that I publish on them. So the main factor leading to ethno-nationalism. So until the general election of 2008, most of the ethno-nationalist groups remained marginal or underground phenomenon. It must be understood that most of those groups are linked and share members and even leaders. The election in 2008 weakened the ruling coalition and revived the old fear of the possibility for non-Malays to take the power over Malays. Several groups came out from the blue and started to voice out their concern, often relayed by racist discourse. Nevertheless, the presence of this group on the media and political scene remained limited. Malay nationalism has been a vivid component of Malaysian politics since the pre-war period when Malayans were living under the rule of the British Empire. Nationalism was a key element in the discourse of anti-colonial movements, being Islamist reformists or secular traditionalists. Malay nationalism always been embodied by the United Malay National Organization, which is the leading party of the ruling coalition created in 1946 and still ruling the country today. Until the creation of Pribumi Perkasa Negara, or Perkasa, a Malay right interest group, UMNO, hold the monopoly in the expression of secular, as in non-Islamist, Malay nationalism. Following the result of the general election in 2008, often compared as a political tsunami in favor of the opposition, and the expression of Najib, the prime minister, to reform the policies favoring the Malay, the old fear shared by most of the Malay community to be overthrown economically and politically by the non-Malays has been crystallized in the discourse of Ibrahim Ali, the president of Perkasa, who is an elected member of the parliament. This non-governmental organization, yet alternatively supported or criticized since its creation by the former minister Mahathir, who is actually the organization patron, has given a new face to Malay nationalism. Perkasa is not the first ethno-nationalist NGO, but remains the most visible and active on the political scene. Perkasa is not a mainstream Malay or Muslim organization, and in fact seems to push further to the extreme the discourse that was until now promoted mostly by UMNO. Perkasa rhetoric concentrates on two main axes, the defense of the Malay rights and religion. Perkasa is a newcomer in the Malaysian public sphere, yet the biggest Malay NGO, claiming 300,000 members. This organization counts numerous Pekida members, so I showed you the logo earlier. It's the underground ethno-nationalist organization and one of the oldest one. And so the Pekida member who joined Perkasa actually did it with the premise of a more political and public involvement. And it's because most of them were really frustrated to actually belong to an underground organization. So they decided to join Perkasa in order to get more public action. And other people who decided to join Perkasa were actually former or current disillusioned UMNO members. Perkasa's strategy aims at countering the political and economical reforms initiated by Najib, which, according to the organization, challenge Malay supremacy, their economic privileges, their identity, and their religion. Perkasa encourages social and political upheaval, and non-Malay parties are calling for its ban. But the government seems reluctant to take action against the organization for fear of losing Malay votes. And in fact, the organization seems to benefit from the support of the most right-wing elements of the ruling party. So in the picture you see here, you have the inaugural Perkasa General Meeting. That was in 2010, so a year after its creation. You can see on the left side of the picture, Mahathir, who's been the Prime Minister of Malaysia for more than 20 years and leader of UMNO. And on the right, you can see Ibrahim Hali, who is currently the president of Perkasa. He's holding in his hand what we call a kris, which is a symbol of a very strong symbol of the Malay identity. And next to this picture, you can see the organization logo, which features actually three colors, red, green, and yellow. Yellow actually represents the royalty in Malaysia. So ethno-nationalists actually all swear allegiance to the royal family and the king. Then, of course, the green color for Islam, and the red color, well, according to them, has many meanings, but it was never really clear to me. So, Vox Perkasa, Vox Populi. The question is to know whether Perkasa is really embodying today the voices of the majority of the Malay in Malaysia. The rise of Perkasa and other ethno-nationalist groups is emphasizing decisiveness over the concept of a current Malaysian nation and identity, revealing the shortcomings of the Malaysian system of governance and nailing down its ambiguities. In fact, it seems that today the government majority has been hijacked by the right-wing lobby and struggle in restoring credibility and trust within the non-Malay constituencies. It is challenging the ruling party and reshaping the boundaries of religious and political pluralism in Malaysia by its attempt to outcast the secular, non-Muslim and non-Malay voices. It is too early to determine now the real impact of Perkasa in the long run, and if truly the organization represents the voice of a majority of Malays. But it seems that the organization holds a strong basis in both rural and urban constituencies. The coming general election will certainly bring crucial elements to the analysis. Thank you.
So, this paper is based on my visit to the Supreme Court of India. And of course, the theme of conversion is a huge theme. The theme of conversions in India is, again, a huge theme. So what I will offer you tonight is a very brief reflection, some thoughts, and first of all, some texts from mainly court decisions on this issue. This is the structure of my paper. I will start from the end, in a way, because it's the latest case judged by the Supreme Court of India last January. on conversion, and then I will try to go back to the background for the case and to give you some clues about developments on the issue. And I will have a very quick part on the colonial background, very, very quick, because we don't have the time to draw on that. But anyway, it's important to, as a reminder of the whole picture. And then I will mainly focus on the post-colonial, so on independent India, and I will focus on what I see as three different phases, one in the 50s, one in the late 60s and the 70s, and the third one at the end of the 90s, and then some quick conclusions. So the case charged by the Supreme Court on January the 21st is a very well-known, worldwide famous case, which dates back to 1999, when an Australian missionary was burnt alive while sleeping in his car with his two minor children in the region, or it's most well known as Orissa, but now the Indian Parliament changed the name, gave its authorization for the change of the name of the state, so now we refer to it as Odisha rather. But this case was first charged by the High Court, and the culprit was convicted. But the case went up to the Supreme Court on whether this life sentence was appropriate or not. And in the decision given by the Supreme Court, where the Supreme Court upheld the decision given by the High Court and confirmed the life sentence, we found two paragraphs which were quite surprising, and I will read them with you. The first one is paragraph 43. Though Graham Staines and his two minor sons were burnt to death while they were sleeping inside a station wagon at Manoharpur, the intention was to teach a lesson to Graham Staines about his religious activities, namely converting poor tribals to Christianity. And one could ask whether there was a need for the court to precise that this murder was purported on this with this agenda of teaching a lesson, and whether this was the appropriate way of wording such an action. Paragraph 47 dealt with the issue of conversion as such, and said it's undisputed that there is no justification for interfering in someone's belief by way of use of force, provocation, conversion, incitement, or upon a flawed premise that one religion is better than the other. So this part of there was a two judges bench, and this the opinion was drafted by Justice Sathasivam, and this is his photo. And what happened immediately after the decision was that there were protests. And in particular, the Hindu, which is a very important daily newspaper, published a letter on 2 days after the decision, published a piece actually, a column, reporting about a letter signed by members of the civil society, and in particular signed by the chief editors of the most important Indian newspapers. And in this, the content of this letter of protest is: leading editors, media groups, and civil society members from across the country have signed a statement taking strong exception to the Supreme Court's observation that the killers intended to teach the Australian missionary a lesson for preaching and practicing conversion. Arguing that the remarks were gratuitous, unconstitutional, and went against the freedom of faith guaranteed by the Constitution, the signatories asked that they be expunged. The signatories said the Supreme Court and other judicial forums were secular India's last hope to preserve constitutional guarantees given to religious minorities and other marginalized groups. And I personally hold the story of how this statement was built and reported in the press by a conversation with the chief editor of the Hindu, Siddharth Varadarajan. surprisingly enough, 2 days later, on January the 25th, the decision was redrafted, was officially redrafted. So the actual official version of the decision has changed, and it's been changed thanks to the pressure of the press. And how was it changed? If you remember the two paragraphs I mentioned before, there was a paragraph about teaching a lesson. That paragraph has disappeared, and it's been replaced by the present paragraph 43. Life sentence awarded by the High Court need not be enhanced, because there was a perspective of applying a death penalty, rather. And paragraph 47, which, as you remember, had this lengthy description of unacceptable conversion and so on, has been reduced to the following: there is no justification for interfering in someone's religious belief by any means. So we have still the problem is there, slightly differently drafted. In the meantime, the Hindu had rectified as well. So it's an interesting case of double rectification, because the court changed and amended the decision, but the Hindu did the same, because after the decision was redrafted, the Hindu, the newspaper, admitted that it was false that the statement of protest had been signed by the chief editor of all the Indian newspapers, of the main Indian newspapers, and it was published in the Hindu on the 26th. So this case raises a question about what I qualify as the no right to conversion doctrine, because whatever the version, whatever the drafting, more or less prudent, there is a big issue on the table, and it's how do we qualify conversion? Does conversion means forced conversion? Does conversion means an abuse in any case or not, and how? And of course, this is a huge discussion in the country, and the social and political significance is very, very evident. Now, as opposed to the social and political significance and salience of the issue, there is a legal confusion, and I will try to go back to how this legal confusion took shape. Well, of course, if we talk about conversion and crossing the boundaries with religious memberships, we can't forget about the colonial legacy and the strategy and the pattern of dividing the country India as other colonies according to communal lines based on religious lines. So the idea of separate communities based on the religious marker. And this is a very, very famous rule of a Warren Hastings plan of 1772. In all suits regarding marriage, inheritance, and caste included, and other religious usages and institutions, the laws of the Quran with respect to Mohammedans and those of the Shastra with respect to the Hindus shall be invariably adhered to. So starting from the colonial period, we have this idea of a recognition of separate communities with separate personal laws for matters of family law. And of course, this strongly affects the issue of conversion. Of course, after the independence, there was a debate. I have no time to deal with this, but of course, it's been an extremely interesting debate concerning both how to deal with personal laws in the Constitution, and immediately after also about how to deal with the reform of the different religious laws. Hindu laws were reformed in the 50s, and precisely in 54, we owe to the Supreme Court a very important decision where the right to propagate religious views for the edification of others. This is the text underscored in red. The right to propagate religious views for the edification of others is recognized by the Supreme Court as a substantial part of Section 25 of the Indian Constitution on religious freedom. And the court added it is immaterial also whether the propagation is made by a person in his individual capacity or on behalf of any church or institution. Now, the same year in Madhya Pradesh, a committee, the Niyogi Committee, was instituted to inquiry on abusive activities carried on by Christian missionaries with regarding to conversion in the state. And this was to become a landmark text, the report which was issued by the committee in 56, a landmark document about what would have been in the future the basic criticism on conversion and the basic attack on conversion. All the arguments which we will find for the decades to follow are already in this document. So conversion is based, the picture is who induces conversions? The rich foreigner, so the missionary coming from abroad with an international agenda, not belonging to the country, bringing money to build facilities, hospitals and schools and so on, and by that means to induce both conversions and so on. Who is converted? A weak and poor tribal or a region, for those who are not familiar, let's say untouchable. How is conversion performed? By force or fraud. So the issue of conversion from this moment on is very much an issue of forced conversion. And the two terms, conversion and forced conversion, are almost synonyms. Criticism on this decision is expressed, but I will have to skip this and go straight to two very important acts of the 60s, which are acts in the states of Orissa and Madhya Pradesh, which for social reasons are states particularly exposed to the activity of Christian missionaries. Both states in 67 and 68 passed acts against forced conversion. And what's interesting is that both acts were challenged before the local high courts. And the High Court of Madhya Pradesh decided that the act was fine, that there was no contradiction with the constitutional principles and so on. But the Orissa High Court actually struck the act and declared it unconstitutional, illegitimate, because in conflict with the Constitution. It's a very interesting case, judged in 72, and which is based on the evidence given by the Christian applicants. This is particularly interesting. I skip to the evidence which is given, and the evidence is built in a way as to give the idea that Christianity cannot be propagated, Christianity cannot be expressed without what the court qualifies as mild threats. And there is this very interesting passage in the decision about how an average Christian preacher acts, which is the preacher says, you non-Christians shall go to hell, or you shall not obtain salvation. And the preacher also often says, wrath of God and shall come down upon you, and so on and so on. And at the same time, in the evidence given by the Christian applicants, there is also a passage about the importance of poverty and social conditions, which is people of the depressed classes in society feel that they are hated and despised by the well-placed section of people. People of the depressed classes embrace Christianity voluntarily as an escape. So you see the entanglement of the different aspects. And on these grounds, the Orissa High Court allows the appeal on the ground precisely that if you have to grant freedom of religion and freedom to propagate religion to Christians, you have to include the right to conversion. So this is the actual framing of the court. The true scope of the guarantee under Article 25 of the Constitution must be taken to extend to propagate religion as a necessary corollary of this proposition. Conversion into one's own religion has to be included in the right, so far as the Christian citizen is concerned. So, as I told you, the Madhya Pradesh High Court takes a completely different position. Precisely in the name of the equality of all religions, you can't admit a specific treatment for Christians. And the case goes up to the Supreme Court, which gives a momentous decision in January 77, shortly after, few months after the principle of India as a secular state had been included in the Constitution by Indira Gandhi, and we are in the emergency, in the period of the emergency rule. In this decision, Justice Ajit Nath Rai, who was a very controversial justice, appointed directly by Indira Gandhi against the Indian judiciary, so a very particular character himself, writes, religious freedom does not imply the right to convert another person to one's own religion, but to transmit or spread one's religion by an exposition of its tenets. What is freedom for one is freedom for the other in equal measure, and there can therefore be no such thing as a fundamental right to convert any person to one's own religion. And you see the entanglement of the different political and social aspects and the confusion. Okay, and the confusion in the legal arguments, because it's extremely difficult to clarify here, what do you mean by right to convert? Do you mean, well, I mean, what is it? I'll be totally unable to give a definition of what a right to convert actually means here, because of course it's sounds like a sort of expectation that someone should convert because of your action, but it remains in strictly theoretical and legal terms very confused, but it's very clear in political and social terms. Third phase, the late 90s and two decisions on the same case. And here we have a slightly different picture, because the case which comes to the court in the Salamudgal case is a case of conversion, of course, but it's indirectly a case of conversion, because the main focus is the application of personal laws and religious personal laws. The relevant case is about a husband who is not entitled to divorce his wife under Hindu law, because there is no ground. Divorce exists, but there is no ground to divorce a wife. So what did he do? He converted to Islam. And he took another wife under Muslim law. And this was not new at all. There is a whole line of cases extremely interesting going back, including English people in the 19th century doing the same. I found very interesting cases on that. But here, and I owe to Justice Kuldeep Singh, I had a very interesting personal conversation with this judge who put forward his very strong University of London education in the 50s, by the way, which is another interesting aspect. And the court gave a very, very strong decision on you can't use conversion to simply to shift to one personal law to another. And so this is the passage, errant Hindu husband embraces Islam to circumvent the provisions of the Hindu law and to escape from penal consequences. And here, this is already a part of the Muslim stigmatization and the Muslim targeting, which somehow belongs to the Indian picture, and which is from the 80s on, from the mid-80s on, very much an issue on personal laws. From the 80s on, we see the issue of religious personal laws as an issue which arises tensions amongst the Muslim and the Hindu communities. And again, in 2000, on the appeal to the same case, this very strong assertion by Justice Syed Ahmad, religion is not a commodity to be exploited. So in a way here, conversion is not accepted on the ground that conversion gives you access to a different legal treatment, and that through these legal treatments, some rights, and especially women's rights, are not protected anymore. So my conclusion is that, as you see, it's extremely difficult to make sense in theoretical terms. So at least for me, it's extremely difficult to make sense of this development in clear theoretical terms, though of course there's a very interesting literature and much can be said. What I would like to say, if we look at what is behind this latest rectification of the drafting of the decision in the Staines case, is that we have first all the problematic implications of conversion in colonial and post-colonial India, and I would rather point on the continuity, in a way, between colonial and post-colonial India, and second, the court's interaction with the changing social context by means of, I would add, confused legal arguments. Thank you.
All right, thank you. Thank you for those wonderful papers, both of you. And I heard it for the first time as well in the second case, almost not be able to see the stuff, and I realized I should have gone back to that spot. But in any case, I think that there are certain areas that I want to make some remarks in terms of comparison with Sophie's new face of ethno-nationalism. I think that Malaysia has always been a very interesting case, and in this particular case, it's important that within Asia, which is, as you mentioned, the size of Antarctica, Malaysia and India are taken again. There are many levels of comparison there in terms of multilinguality, multi-ethnicity, multi-religious groups. And again, very different situations. People always wonder, and as an Indian, I myself wonder what keeps it together. And it's still together, and it's functioning democracy, the largest in the world. But that whole question of what in Malaysia becomes the one hand, the unity has been, instituted in very many different ways. So what struck me, and perhaps you have looked at this, I have several sort of specific comments, but as I was listening to both the papers, one of the questions that came to mind, of course, was the question of if you were to look at Malaysia and the conversion issue that Marco brought up in the Indian case, where would that be in terms of these groups? Because I know that in Indonesia, and I've looked at several fatwas, there's legal opinions, where, as you know, that within Islamic law, the man is allowed to marry a woman of the people of the book particularly, and that's never been contested. But in the last 20 years, in the case of Indonesia, there are many such legal opinions that are given where there is a certain sort of circumspection and circumscribing of that law, saying the woman is the one that is responsible to bring the next generation, and therefore it is better that you not marry the person of the book, the female, unless she converts. So there's been that change or that attitude even within the legal expertise within Indonesia. So Malaysia would be an interesting case where I think we could have some conversation between the two papers in terms of conversion itself. Of course, I was struck by the logo itself and the colors of the logo and the fact that I'm assuming Perkasa is light, right? It means light in Malay? Yeah, so I'm going by the Sanskrit words, and all of those words had so much, Bhumi, you have Pribhumi and Perkasha and Negara, right? All of these things. Obviously, the land and light, and the fact that this particular organization takes the motive of light is an extremely important one, I think, and that needs to be looked at in terms of its efficacy, because you ended with that conclusion about the voice of Perkasa being, is it the voice of the populace? And it certainly seems to have a widespread appeal. And obviously, the images were very strong for me in terms of looking at that widespread appeal. But also, again, and Marco, you ended your paper with the theoretical formulation. I'm sure you've seen tons of it, but as soon as Sophie started and as soon as you started your paper, I couldn't help but think of Arjuna Padirai's work on the fear of numbers. And in both these cases now, so I don't know, you've got a trajectory going from colonial to post-colonial phases. And within that post-colonial, particularly the third phase, I think that Arjun Appaduroi's work would be extremely useful, where you have this extremely sort of almost paradoxical situation where the majority is always threatened by the minority, right? It's the other way. So in most other cases, we're talking about the minority rights, but several of the examples that we have seen, whether it's France and Italy and all of the others, I think that that observation written in the 90s about a different phase with the majority now being threatened. So in the case of India, it is the Hindutva movement. And the idea that although there is a Muslim minority, which is a huge, as you know, it runs into 150 million, but still a minority of 10 to 12%, maximum 15% of the country's population, still poses a very different kind of threat. Within that threat, that last case of conversion as not seen, as a convenience, but also being used in your observation for Muslim bashing or picking that up as the law that allows or compromises women's rights. Because in the 80s, you had the Shahbanu case, and I'm sure you're aware of that as well, which was highly touted, and it was Rajiv Gandhi's time, if I'm not mistaken, where the political parties were highly divided. So I think that within the colonial phase, it's really important that you bring up this landmark Hastings decision where every community in that census is forced to put themselves into a certain category, a certain religious category, which was unheard of, unexperienced within the Muslim context, because people often, several converted communities, the one that I know well enough was several converted communities from local castes to Muslims, and Sufi groups particularly, were forced to identify themselves as either Hindu or Muslim. And that was a very difficult task, even in present-day practices, despite the Hindutva, despite the fundamentalism on both sides, for several groups to identify themselves one or the other, because in terms of practices and particularly shrines, they are commonly shared and commonly visited. Hajeli in Bombay to the Ajmer Sharif. So that, I think, in terms of the colonial times, it's an important point to bring up in terms of identification. Later, as you show in several of the others, the conversion. So in the colonial period, what would be, my question is, and I know better in the Middle East, particularly in Lebanon, for example, the missionary movement obviously was fraught with problems. In the colonial times, it was clearly the case that the colonial powers were Christian, and so the Christian missionaries didn't just come with the money from outside, but also had the backing in some ways, right from starting with the East India Company to that period. And that's very different from now very established educational institutions. And most of the best schools in India to this day are the missionary-run schools. And whether that conversion now falls particularly in the phase 2 and phase 3 of your paper, into more of this, the categorization and the rise of the minority voice, but also what I hate to call it, but fundamentalists or more literalist movements that are coming in. So clearly, I think that, so what struck me, and this might be a completely sort of flippant connection, but it was interesting that now in Malaysia, the language of, or in Madhya Pradesh, in the phase 1, the language of conversion by force was something that was used that was not appropriate. And it struck me that the same discourse about hijab by force is not acceptable. And so that idea of exercising volition or will into this is being used continuously by courts in different forms. And I thought that was interesting in itself. And in the case of ethno-nationalism, Sophie, I thought that why you call it ethno-nationalism, would it be possible to push you into thinking about this also as what the earlier panel increasingly brought up, the whole question about religio, sort of religious symbols turning into nationalizing and nationalization symbols. Where would Malaysia stand in that? Because you clearly stayed away from on the one hand, you concentrated more on the ethnic side. You mentioned the different religions as well that coincide in some ways with the Bumiputra being the rational, the religious side. So within that, would you be able to look at perhaps the question of where do they intersect, the ethno-nationalism and the religio-nationalism, particularly in terms of that symbolic logo form? And I'm going to stop here and allow people to ask questions perhaps, and then have...
One question. I was just struck in Marco's presentation that judgment that was a kind of a semi-fake judgment, then a kind of a fake protest that then got fixed altogether. That's kind of unusual. I mean, I thought it was very interesting how that happened, that the judges wrote that thing in so much detail, expressing themselves, right, about, and then the protest in the Hindu newspaper and all the editors, and then they do some editing work and reduce the judgment to 2 sentences in each paragraph. And the Hindu does this thing and recants himself and said, no one signed. It's kind of a fake process. But I thought in the early period, most of the kind of questions and issues that were raised by the court cases was in terms of Christianity, but the same kind of objections can be raised against Islam too.
But they're not, but that's a separate problem. I'll let you.
But that was a master move on the part of Hindus to do that.
Right.
It was obviously a media.
Yes.
Especially, right?
Yeah.
They obviously, yeah.
Okay. So, Sophie and then Mark.
Well, thanks a lot for your comments. I'm going to try to answer shortly, and we can pursue the discussion further a bit later. So regarding the conversion issue, actually 2 months ago in Florence, I did a presentation on conversion and controversies in Malaysia. So this was the exact topic for my master. I was working on the debate on apostasy in Malaysia. So actually, my research is on Islamist and ethno-nationalist group. Thanks for raising the question on the concept of either using ethno-nationalism or religious nationalism. I don't know. To be honest with you, I've been myself struggling with those concepts, and I'm still not quite sure which one would fit better the situation. So we definitely can talk about that later. So in my research, I show that the governance of religious minority and the legal ambiguities regarding freedom of religion are the sources of major religious controversies that are actually fed by those groups and by Islamist groups at the same time. It's interesting to note that ethno-nationalist groups, which are not seen as Islamist, again, create a common front with Islamists when it comes to religious controversies and the defense of Islam. Again, they're not pushing for an Islamist agenda, so we can see them in a way as religious but secular defender of Islam. The perception of a religious threat enhanced by proselytism, and I'm more talking about, of course, Christian proselytism and evangelist and charismatic group in Malaysia, plays a very important role in the rise of those groups. And it explains as well the reason why they have such an echo in the Malay constituencies. The fear of Christianization, I think, has been present over centuries, right, in Muslim mind, as well as the fear of Islamization for Christians. And today, there have been more and more religious controversies since actually the transition from Mahathir to Abdullah Badawi, because of the democratization process and a stronger civil society, etc. So then this democratization led to more religious controversies and a more visible proselytism in different areas in Malaysia. And again, it helped, I think, the rise of those groups, or at least for those groups to become public and not underground anymore, as I was mentioning earlier. So to go back on the conversion issue, I've seen a lot of things in common with your paper, with paper I presented 2 months ago, so I won't go back on that, don't worry. But just to answer a short question you asked earlier, in Malaysia, so we are, the School of Law is Shafi'i, right? But they just follow some part of it, and then they have their own interpretation of the law. A Muslim cannot marry a non-Muslim. This is not negotiable. Even if it's people of the book, that doesn't work in Malaysia. So if a Muslim wants to marry another person, which is not within the Muslim fold, then, well, this person has to convert. The cases that you mentioned about a Hindu husband converting to Islam in order to, well, get other wife or solve a heavy divorce happen very often in Malaysia as well. But this person would always be supported by religious group being ethno-nationalist or Islamist. And the controversy will always be there. And the controversy in those cases will be raised by women's group or secular civil society group, of course not by the Islamist or ethno-nationalist groups. And then, of course, they will offer the support to the person in the trial. Then to go back on the fear of numbers, you were asking if we are today in a different phase, if now the majority feels threatened by the minority. For the case of Malaysia, the idea of the threat has been there since the early colonial time. This is actually the reason why Singapore was expelled of the Federation of Malaya, just because, well, the Malays were really afraid of being outnumbered by the Chinese, were mostly based in Singapore, and then Singapore was expelled, and, well, I guess happy to be expelled, from the Federation. And today, this group Perkasa is claiming that the Malay in Singapore are being exploited and very badly treated by the Chinese, while the Malays in Singapore actually voiced out the fact that they were really happy to be in Singapore and they were no means they want to go back to Malaysia. So I think I'll stop here, and I'll be happy to talk with you a bit later and give the voice to my colleague. Thank you.
Thank you. Briefly, again on the States decision, if you look at the way it's been redrafted, it's quite evident to me that it's cosmetic, because it's still hanging there in a way. The idea that there was a reason to, they went too far, of course, and they've been convicted, but there was a social and political reason too. It made sense in a way. And that, in a way, that kind of activity is politically unacceptable if it can be declared legally unacceptable. And thanks to the anti-conversion laws in the different states, to some extent it is possible to sanction it legally. It's certainly sanctioned politically. And in this conflict between the journalists and the Supreme Court, the other very interesting point is that this is very much elite. This is a conflict in the elite. I mean, it's extremely difficult to know what the millions of citizens, of Indian citizens, stand for, and so on and so on. It's so complex. It's so huge and so on. Second, a part of this complexity, if you take Christianity and the activity of missionaries and so on, what strikes me is the difference, which is increasingly evident between the perception of how sort of native Christianity or a long resident Christianity, which is widely accepted and so on, and new aggressive Christian movements, evangelicals, for instance. In many conversations, in many interviews I had, I really noticed that people were very angry against the newcomers, because of their methods, because of the fact that they were not familiar at all with Indian culture and so on and so on. So there's a huge difference which is made in that regard. And last answer. There is this point with the colonial legacy. This distinction in communities and personal laws also entails the principle of non-interference. So once you have a community and you have and the community's got its own personal law applied to family matters, you're not supposed to alter it. You're not supposed to step in and change it. And this was, this is the constant problem. And this has been the main problem in two different phases. First, the 50s and Nehru, what they did actually was interfering. And it was interfering on a modernist, reformist agenda. For instance, I give you an example, introduction of divorce in Hindu law. And with a amazing idea of, there is just before the first Hindu Code Bill is passed in 54, Nehru gives a speech and he says, Hindu law has never been rigid. This is what is great about Hindu law. Hindu law has never been rigid. The British, this is the underlying assumption, the British tried to make it rigid, but we have to take it as a living and so on and so on. So that's why we have to change it and modernize it. But it did it through the parliament, through an Hindu Code Bill. So it's been immediately at the time accused by the Hindu fundamentalists of making himself rigid what it was not at the beginning. And with the Shabano and the 80s, it was the opposite picture. You had a decision by the Supreme Court pushing towards a more a friendly interpretation of Muslim law on maintenance rights of women, and there was a massive protest of some sectors of the Muslim opinion. Other sectors wanted the government to stand with the Supreme Court for the sake of a more modern Muslim law, and in the same very week, you had Rajiv Gandhi opening the locks in Ayodhya and starting the big issue. So a very conservative Hindu nationalist stand in Ayodhya and compensating it by standing with more conservative Muslims on the other side, and that's the women divorce bill.
I've been asked to end this, so I just have one thing to say. As the chair, I reserve that right. I'm reading this book, and in the 19th century, a book was published in England called How to Be an Indian Guru. It was a guide for Christian missionaries traveling to India. So, with that, I end the conversation. So all of you, if you want to become Indian gurus, I have the book for you.